welcome to CUHK Law. Welcome to this month's Greater China Legal History Seminar. Thank you all for joining. My name is Lutz Christian Wolf, and I'm your host today. Before I introduce our very distinguished speaker, some housekeeping. As always, there will be some time for Q&A at the end, and if you have any questions, please feel free to use the chat function to chat your question in. I will then read them out, the questions, to our speaker, and hopefully we will get an interesting discussion going. Now, we are very honored to have a very distinguished speaker today. In fact, a very prominent speaker, Professor John Ohnesorge, who is joining us from the US tonight. Professor Ohnesorge is a George Young and Bacon Professor in Business Law at the University of Wisconsin Law School, where he teaches administrative law and business organizations, as well as seminars on compliance, law and economic development, and of course, Chinese law. He's the director of the law school's East Asian Legal Studies Center and chaired the Universities of Wisconsin's China Initiative from 2007 to 2011. He has published extensively on issues related to law and development and East Asia, and has talked and lectured throughout East and Southeast Asia, as well as Brazil and, of course, Europe. There are a number of appointments, a number of visitorships, which I can't all read out because it's just too much. Professor Ohnesorge has also practiced and clerked for Judge Zobel at the Federal District Court of the District of Massachusetts. But most importantly, he is an expert on Chinese law, and today he will talk to us about regulation of the legal profession in China, an historical overview. Thank you very much for joining us, Professor Ohnesorge, and with this, the floor is yours.
Great. Thank you very much, Professor Wolf, and also to Professor Gallagher, who I think is watching online somewhere. It's a great honor to present to this group. I've seen your history series from afar, and it's an impressive thing. Let's see. So I'm sitting here in Wisconsin. It's about 10:30 at night. My background is actually a picture of one of the nice parts of our campus. It's a lake with a terrace. I'd encourage people to come visit Wisconsin if you get a chance. And that's what it looks like in the summer. It doesn't look like that now. It's quite cold, and the lake is frozen. So you can come drive your car on the lake now if you'd like to. So I'm ready to go. Okay, so there's my PowerPoint. Perfect. So let's see, Jay, I'll just say next, and then next. Okay, so this is the outline of what I'll do in the paper. These are the different sections of the paper. The first couple sections are to kind of help you understand my background, the way I study and think about Chinese legal history and legal history in general, and then the section I have called periodization is really, I guess, the bulk of the paper because it walks through different historical eras, and then at the end I offer some conclusions, which I also raise some questions about that I have about the future, what we think is likely to happen in the future. So next. Okay, so I thought I should give you some background both on myself and on the paper. As Professor Wolf said, I've been involved with China for quite a while. I went to China my first job after college was in Shanghai, teaching English in the 1980s. And then I went back to Shanghai as an exchange law student to Fudan University, also in the 80s. So, and since that time, I've been involved one way or another with with the Chinese legal system and observing changes in China and visiting China many, many times. Um, but it's not China. China is not the only thing I'm interested in. So one of the things that sets me apart from some other scholars is I also focus on the region, and I'm at heart a kind of comparativist. So I always think about China in comparison to other countries, um, and I do that also when I think about the U.S. law. Um, and I so a little bit about background. I worked in Korea for about 4 years as a practitioner. So I kind of have a feel for the international business practice and what it's like to practice in Asia as a lawyer. Um, and then I came back to the U.S. and did graduate work in law, which is a little bit unusual for Americans. But I came back and did an LLM and SJD and at Harvard Law School. And so I worked with Bill Alford, who runs the Asian law program at Harvard. And Bill is more of a China scholar than I am, I would say. He's more focused on China, and I'm a little bit more focused on the region. But that's my background. And then I've been teaching at Wisconsin since 2001. So I've spent my whole career at Wisconsin. Um, and about the paper, so the paper, I think this would help you understand the project and then my presentation today. Um, there was a plan of several scholars to do a book about the Chinese legal profession, an edited volume, and bring together a bunch of scholars who study the Chinese, who study Chinese law and the Chinese legal profession. Um, but most of them were not scholars who really studied the regulation of the legal profession. So the editors of the book, I was part of the project, and they said, well, John, would you write a paper about the regulation of the Chinese legal profession? Um, because none of them were, I mean, most of them were things like sociologists or other people who don't really have a feel for the issues of lawyer regulation. And I think lawyer regulation is actually extremely interesting. Um, so I said, sure, I'll write a introductory chapter about the regulation of the Chinese legal profession, um, which required me to learn a lot about the about the regulation of the Chinese legal profession that I didn't know before. Um, and one of the things I do in the paper that you'll see or in the presentation is I thought, well, the goal is to make this, present a broad picture of the regulation of the legal profession. So it has to have a historical aspect to it. And then for me, the historical aspect is, I think it's very important. I mean, I think to really have a good sense of the Chinese legal profession as it's developed, you need to understand a bit about traditional Chinese legal culture. Um, and also you need then so you have to talk about late imperial China and the traditional approaches to the legal profession. Um, so and that's not to say that the traditional Chinese legal profession and the ideas about it determine anything exactly about how things work today, um, but I think there are resonances from the past that maybe people still find important, um, and and then the periodization matters too. So to make a legal history overview sensible, you have to divide it up into periods. And I've done that in I think kind of a standard way. But if people have questions about my choices about periodization, I'm happy to talk about that too. Next. So I thought I'm not a professional historian, but I think it's important to have ideas in mind about your methodology when you're even an amateur like me is going to write a legal history. So I think there are a couple things that I'll just talk about up front. And well, the main thing is a functionalist approach to these topics. By functionalism, I mean um, both a functional definition of what a legal profession is, and then a functional definition of what regulation of the legal profession is. Um, so, what do I mean by a functional definition of the profession? That's really well, it's useful both in the imperial Chinese past and for periods after 1949. For me, a legal profession, in a functional sense, is just if you have a group of people who provide professionalized services um, dealing with the legal system. And it could be dealing with the legal system as it in sort of a horizontal way. So if there's a group of people who provide services um, for individuals let's say suing other individuals, um, or dealing with family matters or property matters or things like that, contract matters between individuals, that would count as a legal profession. Um, or people who specialize in providing legal advice, legal interpretation for citizens dealing with the government or the state, however you want to say it. So that would be like a vertical, if there's a group of people who provide services for other citizens dealing with the state and a vertical sort of axis, or people who provide legal advice, legal services between citizens, sort of horizontal. Um, and so there are other ways to define a profession. Obviously, in professions now, there are modern definitions of what a profession is, and they usually include um, things like having exam to enter, having professional norms, having boundaries about who's in the profession, who's out of the profession. Um, but functionalism is useful for comparing uh, into the past. So it's, if you go back in time and you say, well, if you said, well, there's no legal profession because there was no bar association or there was no formal exam or something like that. If you insisted on defining a legal profession by today's metrics of a profession, then you'd miss a lot. Um, and that's true in comparative work too. If you're trying to compare legal professions across two different societies, functionalism is helpful because it allows you to take a broader view and maybe not miss um, understanding people who are doing something that actually kind of should count as legal provision of legal services. Um, and so, if you like in the like say in the well, after 1949, China has at points had what people called like grassroots lawyers. There's a legal sociologist at Hong Kong U, Liu Sida, and Sida has written quite a bit about grassroots lawyering, and I think it reflects also a functionalist view. Because it's a group of people who provide legal services in a sense, and to understand how legal services were provided in China, you needed to understand that the phenomenon of the grassroots lawyers. And then for the regulatory purpose, it would be, well, how did the state regulate that group of people's behavior when they did that? Okay, so and on functional definitions of regulation, for me, in a broad sense, the regulation of the legal profession would be any legal tools or legal measures that regulate those people that are providing the services. So, in a modern sense, you look at rules from the Ministry of Justice or the statute, the lawyer's law, or the rules of the bar associations, the All China Lawyers Association, and that's obviously all part of the regulation of the profession. But more broadly, lawyers are also regulated in a sense by like malpractice law, tort law regulates the legal profession. Criminal law can regulate the legal profession. In the Chinese context, I think it's important to broaden out the definition even further to include things like the hukou system, which um, has effects on the Chinese legal profession because lawyers have to be, that a lot of you will understand that better than I do exactly, but you can say, well, the hukou system does, in a sense, regulate the way that lawyers in China are able to practice, where they can practice, and things like that. Um, so I wanted to talk about methodology a little bit at the beginning to help you understand um, my project in the paper. So next, okay. So another aspect of the paper is that it's kind of a view from above. It focuses a lot on kind of what the government is trying to do with its regulation of the profession. And that's not the only way to study things. I mean, there are other historians would say, well, you should study things from the ground up, look for, bottom up explanations of things. Um, and that's all true, but I think for an overview of the regulation of the Chinese legal profession, I think a kind of a top-down view is definitely necessary. It's not perfect, it's not complete, but I think it's definitely the place to start, is to look at the official attitude toward the legal profession over time, because that tends to be represented in the regulation that you see. Um, and to provide a sort of a story about that helps tie this all together, so that legal history isn't just a list of a bunch of facts. It's possible to write histories that are just a list of facts, and I really didn't want to do that. So I was looking for some way to make sense of what we've seen over time with the Chinese legal profession as it's was invented and developed and then has had its setbacks and then has been kind of revived. Is there a way to provide a kind of heuristic or something that will tie this whole complicated story together? And what I decided to use is, it's actually, I don't claim that this is original to me at all. I think that other people have said the same thing about other writing about other aspects of modern Chinese society. But it seems to me, as I looked at this, that if you're trying to explain the leadership's attitude toward the Chinese legal profession over time, as it's expressed in the regulations, there seems to be two poles, or it's like a yin and yang kind of approach. Um, on the one hand, you see something that it ebbs and flows, but it seems like it's always there, is a desire to maintain political control, and political control it's important to maintain control of the legal profession if you want to maintain political control. And I think that's been true, and that's part of the story of the development of the lawyers in the West, countries like Germany or the US. And in some countries, the government really doesn't have that much control over the legal profession. And we talk about, the lawyers in countries like that have achieved a pretty high degree of kind of self-regulation. So the profession has managed to kind of get itself out from under state control in some countries. But in lots of countries, the government still plays a strong role in regulating the legal profession, and that's been a kind of constant, I think, in China's approach over time. Um, and then on the other hand, um, there are external pressures that have at times pushed the Chinese government to loosen its control over the legal profession, or to encourage the development of the legal profession. Um, and these things, you can sort of trace the history by telling a story of the balance between these two impulses or imperatives, or whatever word you want to use for these two kind of forces they push in a little bit different directions sometimes. Um, And that shouldn't be overstated. I mean, that can be kind of a problem doing comparative work, is to assume that these kinds of models are actually stronger than they are. Um, and people have done that a little bit with Japanese politics over time. There's an idea that all Japanese politics is always driven by external concerns, demands from the US or whatever. Um, and if you overemphasize that, then you can ignore what's actually happening inside. Um, and because there are internal pressures too. But I think in the Chinese story, it's important to talk about the external pressures because I think they mattered quite a lot. Um, so next, okay, so so this is my periodization, and this I would say isn't really controversial either, and it's not original to me. I don't claim that this periodization is original to me, but um, I think it's good enough. It's not perfect. You could certainly split the Republican era into different um, sub periods that display different issues, different tendencies. But I think this is good enough for now. So what I want to do then in the rest of the paper, I'll walk through what I think the most important things to take away from the different periods. Um, and then, when we get closer to the present, I mean, this is kind of ironic, but the past seems more clear to the present. Once we get close to the present, the picture becomes kind of fuzzy, and so I end the paper with just some questions about maybe what we should expect in the future. Um, and I would say, my orientation is as an American lawyer and scholar, so I have kind of a normative bias toward self-regulation by the lawyers to the extent possible, because I think it's good for a kind of pluralist political system, a democratic system, for the lawyers um, to have a kind of prominent role, um, and that and so to have a prominent role in the political system and in the democratic system, it's good that they have a fairly high degree of freedom to regulate themselves. Obviously, lawyers also have self-serving interests and other interests, um, but on the whole, I think it's a worthy um, goal. That's my own basic orientation toward the legal profession and regulation. Okay, next, Jay. Okay, so in this part of the paper and it just in general, I think it's interesting to look back. China obviously had a very long legal history prior to the fall of the Qing, very long. But um, there are some important things that come out of looking at that history, and I've done some of that, but I'm not a professional historian. Um, so it's not I don't do like archival research back into Chinese traditional law. But one thing that comes out very clearly from looking at that is the usefulness of a functionalist definition of the legal profession. Um, because there were always people, apparently, as far as we know, there were always people in traditional imperial China that provided kind of professional services to others who were dealing with the official state legal system. Um, and they did it um, both, as I understand it, both between individuals, this kind of lateral professional services, and then also some people um, played a kind of intermediary role between the bottom level of the state bureaucracy and the people in a region. So both, and obviously that group of people didn't have the characteristics that we would often say are necessary to constitute a profession today. There wasn't really licensing, I don't think. I mean, Um, and they weren't self-organized into a bar association or anything like that. But they clearly played an important role in Chinese society in the past. And partly, that because so much effort was spent um, trying to suppress them, or at least keep them within a kind of boundary. Um, One of my colleagues here at Wisconsin is an actual historian, a Ming scholar, and one of his research projects has been collecting anti-litigation songs from Ming and Qing China. You can find if you can get into the archives, you can find old anti-litigation songs, hundreds of years old, that were designed to discourage litigation by people. Um, so that tells me, well, there were people doing this, because if there were no people doing it, you didn't need songs to discourage the behavior. And then there were kind of well-known terms to describe the people that were providing these services. This is Songshi and Songgun, and these kind of derogatory terms for the people providing these services. Um, so it's an interesting question then. People are providing the services. Everybody knows it. The state clearly wants to keep them bounded in terms of what they're doing and how important or powerful they get. On the other hand, there must have been a sense that they were doing something useful in some way, um, and so they were regulated, but never driven out of existence as a kind of thing to do. And so some of the stuff I have in the paper is from people who studied the guilds, the commercial guilds and clans in traditional China. And in both the writings about the guilds, the commercial guilds, um, there were people in the guilds who helped represent the guild in its dealings with the government. So that's kind of a thing that a business lawyer would do now. You'd have the Association of Bankers or something. They would hire lawyers to help them deal with the banking regulators. And that's not totally unlike what the guilds apparently did in traditional China. And then there were clan people who studied the clan rules and things like that from traditional China. Also um, wrote about clans um, having internal rules about, or just policies to discourage people from taking clan disputes to the official state legal system. Uh, so anyway, my reading of that in terms of these two kind of imperatives, or my model, um, clearly in that era, what I would call the control imperative was ascendant, right? And the government's desire to keep this group of people from becoming really a kind of independent profession, um, while also sort of tolerating them in a funny way. And one of the sources for understanding this is reading what we call in English the magistrates' handbooks. So these handbooks that were written by famous magistrates. Um, some of those you can get those and read those, and there's a lot of discussion in those about how sort of advice to magistrates about how they should deal with this group of people who are providing these kind of services. Okay, um, so that's the kind of imperial background picture, and I think, as with when we get to the post 1978 period, it's a little bit the same. To understand what happened after 1978, you have to understand the state of the Chinese legal profession before 1978. And I think in that same way, the imperial background is important for understanding what happened in China as that was ending. So into the Republican period. Next. Okay, so what I call here the Republican period is actually longer. I mean, I would say it stretches back to the beginning of the treaty port era in the 19th century, because to me that era is very interesting. You know, when the foreign law firms, foreign lawyers, foreign law firms start coming into China, mainly I would say through the treaty ports. Um, they they provided a kind of model and driver for the creation of the modern Chinese legal profession. Um, and it's interesting, I think in some ways what they may have brought mostly, well, a couple things. One was the idea of that a legal profession could be a kind of respected thing, and it's okay to have a legal profession. And then the way to organize a legal profession in terms of how law firms are organized. What is a law firm? How is it organized? Things like that. Um, they didn't bring the idea of providing legal advice because that idea was already in China historically. But maybe what they brought was a kind of legitimation of the idea that, well, it's okay to have a profession of these people. It's a respectable thing to do. Um, because also, China had long had exams. So the idea of having an exam necessary to enter a certain profession, that wasn't new either, that the foreigners brought. Um, so in those cities, the treaty port cities, the Chinese people, Chinese business people were exposed to this idea of a law firm as organized in the West. Um, and I haven't studied it in depth, but I mean, I think there's a sense that in a city like Shanghai, there was a lot of interaction. Um, and the and part of that was bringing legal education, so that's Shanghai had this some law schools that were opened um, sort of by through the missionary universities. Shanghai famously had the Dongwu School, which went by various names over the decades. Um, but that started pretty early on, and in the treaty ports, um, because of the jurisdictional issues, there were also, the examples of courts, how to run a court in the Western sense, the consular jurisdiction, all that stuff. So um, after the fall of the Qing, once the Qing has fallen and the Chinese law reformers start, the law reform effort takes off, pretty early they start trying to regulate um, a Chinese legal profession, which kind of has, that it has to be created pretty much from scratch. And so you see, early 20th century, you see um, regulation of Chinese law firms, bar associations form, um, things like that. And I think it's an interesting mix of influences from Japan as well as from the West, because as you know, I think a lot of um, young Chinese were also going to Japan to study, and Japan then became a different kind of conduit for foreign ideas to come in. By that time, Japan had gone pretty far in developing its own kind of Western style legal system, mixing German and French and other Western influences. Um, so, I would say to really study this, you need to study both the ideas and forms that were coming from Japan and directly from the West. Um, and at that point, um, you can identify, well, during that era there was an external force that was pushing the Chinese leadership to develop a modern legal system and liberalize, create a, have a modern legal system, recognize a legal profession, that stuff. And people usually have identified that force as the extraterritoriality problem. That um, there was a desire, obviously, by the Chinese leadership to end extraterritoriality, and so one way to argue that it should be ended was to say, well, now we have now a proper legal system of our own, and your excuse for extraterritoriality is no longer valid because we have a legal system. Um, and I'm sure that was important. It's with this idea about these external, internal, external forces. Obviously, you can't really quantify these things, but I think everybody agrees that was important, um, and among other things, right? So, but if on the other hand, China was not, um, I would say it didn't go very far toward creating a really autonomous legal profession either. So I would say it was sort of a modernized legal profession, but still in kind of a state-centric model. And so I don't think people would argue that the Chinese legal profession during this period really achieved kind of self-regulation or autonomy from the state. Um, Certainly, some people wanted it, but it doesn't seem to have been achieved. Um, and why did people want it? I mean, if you look at that era, you see a developing rights consciousness among Chinese people, and a rights consciousness in the sense of putting desires for a better society into the language of rights, which I would say was mostly imported from the West or via Japan. The idea of things like democracy and things, the way democracy would actually work, and the idea of individual rights legally protected, those things, they certainly had antecedents in traditional Chinese society, but the way they came to be expressed in the early 20th century, um, with that kind of demands more freedom for the legal profession. I mean, if you really are concerned about individual rights, and you want your country to be organized around individual rights, and you want your country to be a democracy, then it's kind of natural to think, well, we need a legal profession that can really help lead us to get these things. But on the other hand, the government's control imperative seems to have remained quite strong all the way through, and against the real freeing of the legal profession. Okay, next. Okay, so early 1950s. Um, so when I went to China in the 1980s, you could still meet people who had experienced the early 1950s, legally trained people from before the revolution who stayed in China um, through the early 1950s. So one gentleman that I got to know in Shanghai in the 80s had been a judge in Shanghai in the late 40s, and so he had experienced this turnover in after 1949. And one of the funny stories he told me was, well, the government, the newly declared People's Republic, early on abolished a lot of the existing legal system because it was bourgeois and capitalist market oriented bourgeois legal system. So it was abolished. Um, and he said, but in Shanghai we still had cases and we were still judges, and you need. So we made up kind of our own set of rules to govern procedures in the Shanghai courts because the official rules had been apparently abolished. And I always thought that was an interesting story because it tells you something about lawyers and the training of those people who were trained before the revolution. I think in the early 50s nobody was sure what was going to happen. So for a while, they thought they would carry on. Um, and for the judges to carry on, they needed some rules. So they kind of created some rules of their own to keep the courts open. So that didn't last very long. I'm sure people here know that story better than I do, but I think the pretty soon the private bar, the commercial private bar was essentially destroyed, and people were purged and things politically. Um, and I think that story is pretty well known. There isn't much written in English about that, which is unfortunate. The other thing that was also interesting and there were people in Shanghai in the 80s who had been involved with this too, was I'd say my impression is this went on into the mid 50s, was an effort to build a Soviet legal system, um, along the lines of the Soviet Union. And the Soviet Union, always had a more institutionalized legal order than, say, Mao was in favor of, right? So this was part of the whole difference between Chinese communism and Soviet communism. Soviet communism was more formalized, more bureaucratic, um, and there were efforts to draft some codes and things during the 50s that were going to kind of model this legal system in the Soviet Union. And that legal system, I think, assumes that there would be some kind of legal profession. So obviously, it was not going to be an independent legal profession that could challenge the leadership's authority, but some kind of legal profession was, I think, understood to be part of the Soviet model of Soviet legality. Um, okay, next. So this period, um, I think for purposes of a paper like this, I thought, well, the late 50s through the end of the Cultural Revolution um, could probably be treated as one extended period, starting with the anti-rightist movements of the late 50s, which my understanding is, legal training from before the revolution um, caused a lot of people to be purged again or persecuted again in the anti-rightist movements, having legal training in Shanghai or a place like that. Um, for many people, kind of marked them as a rightist in some sense. Um, and then that merges into the Great Leap Forward famine. Um, and in terms of the regulation of the legal profession, I think it kind of disappeared. I think the legal profession kind of disappeared, at least in the sense that you'd want to write about it. And then the Cultural Revolution comes along, and um, so and this, you could say this represented a rejection of even legality as practiced in the Soviet Union. I mean, this when political science people talk about this as government through party campaigns, government through campaigns. And if you're going to govern the country through campaigns, you don't need legislation, you don't need lawyers, even government lawyers. And so you certainly don't even need Soviet style organized legality. And in a funny way, that period was also, I would say, the period of greatest economic sort of autarky. So if you think that an imperative to engage with the international economy can influence the Chinese leadership to, support the bar and open up a little bit. This point, this period also represented, I would say, the high point of China's de-linking from the global economy. Um, so if that's the case, then there's really not much to counteract the control imperative. Um, So if you see these two things in tension, there's always kind of an imperative from the leadership to control the legal profession. Um, and sometimes that's offset by a countervailing force to kind of support the legal profession, or at least allow the legal profession to exist and do its job. During this period, the control imperative seemed just ascendant, and there seemed to be very little to counterbalance it during that period. Um, and to really figure this out, it would be interesting to know more about how China carried out what little international trade it did. I mean, I think if you dug, you'd probably find that there were always some Chinese lawyers who understood maritime law, to deal with imports and exports of grain and things like that that took place even in the most kind of autarkic periods of Chinese economic policy. There was always a kind of barter trading regime in the Soviet bloc. Um, but but I've never seen anybody try to study that. So, but I'm guessing there were always some lawyers who probably worked inside the Chinese government in some way who were able to undertake kind of a maritime law practice. Um, okay, next. So this begins the period that people were probably expecting to talk about the most, which is the kind of reconstruction of the Chinese legal system. Um, and as I said before, to understand this, to make sense of what happened after 1978, you kind of need to understand what happened before, which is, as I would put it, the Chinese legal system had basically been kind of destroyed. Um, so there was no need for lawyer regulation at all. So 1978, I describe a single kind of period from 1978 to roughly 1990, um, rehabilitating the legal system, reopening institutions, and reconstructing kind of the framework of the legal system, which would then also pretty early on would include recognizing that there was going to be a Chinese legal profession, and then the very beginnings of regulating this legal profession. Um, so, um, and why this happened, people will have different ideas about it. Part of it for me, was clearly related to a desire to reconnect with the international economy. So to do that, is reform and opening stuff. Um, the Chinese leadership had decided to re-engage with the global economy. And what's interesting to me as somebody who studies economic development is they had decided to re-engage, and I would say kind of modeling their economic policy after what had happened in Japan and Korea and Taiwan, which was an export-oriented development model. So there are other development models, and it's interesting because, as a socialist country, you might have expected China to try to have a more socialist economic policy, but I don't think that's what they did. I think by the way I read Chinese economic development policy, it was mostly based on looking at what had happened around China in the region, and deciding that, all right, well, we're gonna try to kind of do what the Japanese and the Koreans and the Taiwanese did, which had proven to be quite successful already by that point in time. So to do that, what kind of demands does that place on your legal system? Um, you have to allow foreign direct investment. So you have to have some legal framework, or the foreigners are not going to invest. They're not going to come you can open special economic zones. And so that requires some legal framework. You have to have rules for your special economic zones. And then you have to have You have to have some basic rules about how the foreigners will invest, and that's the early Chinese joint venture law, the early Chinese tax law. Um, and then you need to recognize that lawyers will play some role in this economic model. So that's kind of I would say the external motive force at this point driving the regulation of the profession. And so the regulation at this point becomes, well, all right, we need a legal profession now. So how do we get a legal profession? We reopen the law schools. We bring back some of the professors who had been sent to the countryside in the Cultural Revolution. Um, we bring in foreign experts to come and teach people about the GATT system and the international, the sort of market-led international system. Um, and I think that has to be if you want to understand the Chinese government's attitude toward the legal profession in that early period, I think it clearly was linked to the development model and an export-led development model. Because for export-led development, you need technology, and so that means you have to license technology or import it some other way, and that requires lawyers. Um, and then on the other side, an internal driving force for recreating a legal profession, I think it really is internal, which is that the leadership had decided, I think, against sort of government through campaigns organized by the Communist Party. I mean, the Deng Xiaoping generation had clearly decided that they wanted to legalize, in a way, Chinese society, the governance of China and Chinese society, um, to some extent. So this was the beginning of these interesting discussions about, rule by law versus rule of law. What's the difference between rule of law and rule by law? The academics have spilled endless bottles of ink debating this, but clearly they decided they wanted some level of rule through law at this point. And I think that was important, and I don't think that was driven by I mean, people don't think that was driven by the external forces. I think people would normally attribute that to things like the personal experiences of people like Deng Xiaoping, who had experienced the downsides of kind of lawless government, and so wanted to regularize and legalize the way governance worked in China. And so that requires a legal system, and it requires lawyers to help operate the legal system. So, and then in terms of internal economic reforms, this was also the era when reforms were happening, economic reforms were happening in the countryside, in agriculture. So the household responsibility system, the idea that people would be able to keep some of their crops and sell them for cash, that assumes that there's going to be private property again. That assumes that property will be protected legally, and that assumes that there will be lawyers and courts and all these things to do that. And in the cities, this was the period also when people were being allowed to leave their work units, the Danwei, leave the Danwei and form private enterprises under the Getihu system. So all of that requires then lawyers. And as I said, they're both internal and external economic motivations for doing that, which I think helped loosen up or counteract the normal desire to have control over this for political reasons. Um, so let's see. Yeah. So just something about the form this took. I mean, people are familiar with this. It kind of followed a classic uh, modern Chinese approach, which is experimentalist. You start local, you start with just the bare minimum of what you need in terms of a legal system. You start locally, it's an experiment. If it doesn't work out, you can always shut it down. If it works well, you can formalize it. Um, and that, political scientists or economists who study Chinese policy in general, that's a constant, that's a constant way that people describe the pattern of Chinese reforms. And for me, as somebody who studies law and development, that's very important to understand because often people who write about law and economic development um, seem to believe that a formally well-constructed, comprehensive legal system is somehow a prerequisite to development, and that you need to build out kind of a complete legal system in order to get development. And the Chinese case shows that that's just not correct. The Chinese story is the better reading of the Chinese story is that you can start with legal reform, you can start small and close to the bottom, and you can focus on the specific legal areas that are necessary for your economic development policy. And then as the country gets wealthier and as you learn what you really want out of your legal system, then you can formalize it. And that just happens over and over and over in the modern Chinese history. I mean, I tell my students here, I mean, China had stock markets. China opened the stock markets before they had a company law. So at least a national level company law. And you say, well, that's kind of interesting. We would normally say, well, what are you trading on a stock market? You're trading legal rights. So you would assume that you would have a national company law in place first, and then people would buy shares and they would trade according to their rights. Um, but no, you can do it the other way around. Um, and so the legal, the specific rules about the legal profession that you saw created in the late 70s, early 80s were also, they tended to be temporary, temporary rules about lawyers or whatever. And then gradually they were replaced by more sort of national level laws. Um, okay, so next. Okay, um, so this I would say is the next to the last period, and this is kind of, I would say, the kind of maybe in retrospect kind of a golden age in some ways for the Chinese legal profession and the regulation of the legal profession and including the foreign firms that had entered the Chinese market. So, by 1990, I think the basic regulatory framework was in place that we're still living with. Um, and the regulatory regime for foreign firms is established. And one of the reasons I wanted to write about the foreign firms in modern China is because I think the foreign firms had played an important role back in the early 20th century, and not to glorify the foreigners, but if you want to be honest, the Chinese legal profession before 1949 developed in close connection with the foreign law firms and foreign legal models. Um, and it did so again in the reform period. So, so that the system, um, there's the formal system, which people here certainly know that better than I do, but there's a bunch of regulation that looks pretty much like lawyer regulation in other countries. There's the Ministry of Justice and the Bar Association, and it's parallel. Um, and in classic Chinese fashion, the institutions of the national government they have corresponding branches all the way down to the local levels. Um, and as in other countries, they have statutes that create those organizations, and then they're delegated some rulemaking authority to make more specific rules, regional rules, things like that. Um, one of the interesting things to say about all that is that the Bar Association, um, the way I describe it to people is it functions as a what political scientists would call a corporatist, authoritarian corporatist thing, right? It exists, but it's controlled by the government to a much greater extent than you would think if you thought, well, I'm going to study the Chinese Bar Association. If you assume it's like the American Bar Association or something like that, you're just missing the function of it. Um, it's and China didn't invent this. I mean, it's a corporatism. This kind of corporatism has existed in lots of countries. It existed in famously in Italy in the early 20th century under Mussolini. It's a way that industries are organized into mandatory associations, and then the government, the top of the mandatory association, is kind of controlled by the government. Um, so that still remains true. So um, in the in the 90s and through this period in the early 20th century, there is, as I'm sure people here know, there were plenty of efforts to get more independence for the Chinese bar associations, um, and there was certainly some progress in that direction. Um, but never probably a lot. That the progress that was made ties with other sort of movements during this period, things like trying to separate the government and the party. The idea that the government and the party in China should be more separate than they had ever been. The government itself should be recognized as something independent from the party. The effect of that would be to make the Communist Party more like a political party in a multi-party country, reduce its role, and for people that wanted that, people that were advocating for that, um, that's the kind of political reform that would have also supported a more independence for the lawyers. Um, so and then beyond that, so I'd say my argument in the paper is that stuff looks kind of like lawyer regulation would look in other countries. They have regulation about entry to the profession. Um, so at this point, there's an American scholar wrote about this idea that legal profession regulation regulates two things. It regulates production of lawyers and it regulates production by lawyers. So regulation of production of lawyers, those are the entry barriers. What you have, educational requirements, passing a bar examination, that's a whole bunch of regulation that regulates the production of lawyers. And in the Chinese context, you don't really need that until you get too many lawyers. I mean, you don't when they started the reforms, they were trying to get more lawyers. So there wasn't really a need to restrict the number of lawyers too much. Um, and in a developed economy, a lot of the restriction comes from the existing lawyers who don't want more competition. So regulation of the production of more lawyers so if you look around Asia, I mean, it's often the existing bar associations working with the Ministry of Justice who keep down the number of lawyers, and that's probably not so much a political thing as it's a protectionist measure by the existing bar. Um, and then the regulation of lawyers, that would be or production by lawyers, that's conduct regulation. So not entry regulation, but conduct regulation. And that was also built out in this period, 1990 to 2012. Before that, when all the lawyers were really state workers, it probably wasn't that necessary to have an elaborate set of rules about the practice of law. Because in a society like the U.S., that's a lot of what lawyer regulation is. It's conduct rules about how lawyers are supposed to behave. When everybody's working for the government, you don't really need much of that. But as the Chinese legal profession developed, that became a big part of the regulation, which is normal. Every country with a developed legal system has that. Um, and then if you expand that, the sort of functional definition of a legal profession and functional definition of regulation, then you look at areas like criminal law, tort law, and that's kind of interesting too. So, there was controversy in China about special provisions that were added to the criminal law to regulate lawyers specifically, which is kind of a little unusual. I think probably most, at least the countries I know of, don't really have special bits in the criminal code specifically targeted at lawyer behavior. Um, but they may. I mean, that's not, lawyers should follow criminal law too. The question is whether you have special criminal provisions written just to keep the lawyers under control. And then the tort law story is interesting too. I mean, because malpractice litigation and malpractice rules are obviously a way to regulate lawyers. It's not regulation in the sense of rules, it's regulation in the sense of um, allowing people to sue them for malpractice. And I have a little bit about that in the paper because it looks like, um, I mean, that has been slow to develop in other Asian countries too. I mean, I think it's probably protectionism partly by the lawyers, but it can change pretty quickly. So you can go from a situation where nobody ever sues lawyers, lawyers will never lose a malpractice suit, to situations where they start to, and at that point, lawyers obviously need malpractice insurance. So then you start to get the malpractice insurance industry, and it looks like China has gotten to that point. The research I did, it's a little hard to research this unless you go talk to lawyers practicing in China about it. But it looks like the threat of malpractice litigation is now actually it's a real enough threat in China so that people have to get professional malpractice insurance, and that's just normal right around the world, at least in the developed legal systems. Um, but also in this section, I also talk a little bit about the hukou system as one of these things that is not common in other countries, right? So that if you really want to understand um, how Chinese lawyers, their behavior, their lives is regulated, um, for some of them, the hukou system really matters because it affects where people can get jobs. Um, Losing people can be forced to leave a city if they don't have a hukou for that city. And I think this would most directly affect um, kind of human rights lawyers, lawyers for dissidents, things like that. They're the ones who are likely to run into problems with their hukou if they're practicing in Beijing and they don't actually have a Beijing hukou or something like that. So it probably, my guess is it doesn't bother the business lawyers that much, but it can certainly be a way um, to control and tamp down the behavior of lawyers who are um, pushing the state in directions that the state doesn't want to be pushed. Um, and this period, for the foreign law firms, this seems like it was kind of the golden age. I mean, the foreign law firms came in legally in the early 90s, the famous licensing of a bunch of foreign law firms. And then you just got this really interesting phenomenon of the foreign firms and the Chinese firms kind of building this Chinese business practice together, playing different. And I guess one way to think about it would be that their roles at the beginning were quite different. The foreign firms' offices in Beijing and Shanghai um, did things that were quite different from what the Chinese business firms were doing. And then over time, that's what they do has come closer and closer. Um, and they became very intertwined. I mean, the careers of lawyers moving from one to another, lots of Chinese lawyers worked for foreign firms. Um, Eventually, Chinese firms started hiring foreign lawyers. Um, and I'm interested in that because that's what I did. That was my first job, was a lawyer in Korea working for Korean law firms because the Koreans, and this is a sign of China's pragmatism, the Korean legal market was much more closed to foreign law firms than the Chinese legal market was. The Chinese government was very pragmatic about letting the foreign law firms come in. Um, I mean, some of them were there before the licensing was started in 1990s. There were foreign law firms with little sort of unofficial offices in the 1980s. Um, and the Koreans never allowed that. The Koreans watched the foreign lawyers very, very, very carefully, and they would not allow that kind of unofficial practice. And so, I think to me that demonstrates a real pragmatism on the part of China's leadership at that point. And it was pragmatism driven by the desire to integrate with the global economy, develop through export-led growth, encourage foreign direct investment, all that stuff. And so I think my reading is they decided, well, that's what we really want. And so we're willing to relax the controls a little bit to accomplish that. Um, so, um, yeah. So next, Jay. So 2012 to the present. I mean, this as you figured out, this kind of corresponds with Xi Jinping taking power. Um, and again, I think this is not a period. This is not an identification of a period that's unique to me. I think a lot of people see real changes around this time or shortly after 2013, 2014. And it's interesting. I mean, it's kind of a conflicting picture. Clearly, the control imperative has been sort of emphasized, government control, um, anti-corruption campaigns, tightening up of ideological control and officials, that kind of stuff. Um, so things specifically like the momentum to separate the party from the government, that seems to have been reversed, and actually kind of accentuated party government interaction. Um, And in some way, I think it's related to a drive on the economic front for kind of not autarky, not going back to autarky, but less dependence on foreign capital, um, less dependence on FDI, the um, made in China initiatives, the innovation, the sort of domestic innovation initiatives. Um, if that works, then there's just less, like specifically for the foreign law firms that operated in China, there's just less of a role for them. Um, so if like say if Chinese companies are going to raise capital in Shanghai or Shenzhen or Hong Kong instead of listing in New York, then that capital markets work can be done more by Chinese law firms. You don't need the foreign law firms there. Um, so I don't think the formal regulation of the Chinese legal profession, the formal regulations, that formal structure has changed that much. But I think, I think people would say, well, there's been even less tolerance of like the human rights lawyers, the rights defenders lawyers. Those people have been really cracked down on more. Um, And so Chinese lawyers, if you're looking at the whole Chinese legal profession, both the elite business firms and then also the other firms, um, I think there's certainly a sense that there's more government control. On the other hand, there's this interesting government support that I don't really understand. Um, but I think to me, it's related to the desire for independence in other ways. I think there's a desire for less dependence on the foreign law firms. Um, so there's this idea that the Belt and Road Initiative that contracts will be governed by Chinese law to a greater extent, that dispute resolution will be done in China to a greater extent. Um, Maybe the Chinese courts more than they used to be involved. So, and if that's the ambition, if the ambition is to have sort of a Chinese legal infrastructure to support the Belt and Road Initiative, then you want to support the Chinese legal profession in a way. Um, and you also want to support them going global. So we've had these experiments um, in early in Xi Jinping's era, in the 2014, there were these experiments allowed that looked they were advertised as allowing joint ventures between foreign law firms and Chinese law firms, so that the foreign law firms would actually be able to hire Chinese lawyers or work with Chinese lawyers and wouldn't be cut off from Chinese law, from the Chinese courts, from Chinese practice. Shanghai, I think the Pudong zone was going to be a zone where they'd allow these kind of liberalized joint practice rules between foreign and Chinese firms. Um, but within a few years, we got legal changes that have made it, I think, more difficult for the foreign firms to operate in China. Things like the national security, state secrets kind of rules, and some enforcement actions in Beijing that got a lot of international press toward uh, like services firms, joint, kind of due diligence firms and that stuff. And so we've seen this, and I'm sure people here are aware of that, this exodus of foreign firms from China over the past 3 or 4 years. A lot of them have closed offices in the mainland. Some have relocated to Hong Kong. Some are closing their Hong Kong offices. And that's one of the questions at the end. So, Jay, can you go to the last slide? Next. Yeah. So, oops, not that. Yeah, that one's perfect. Yeah. So I just would sort of end with these questions. So the first one would be, well, have we witnessed the rise and fall of the foreign law firms in China from 1990 to 2025? I mean, that was like a 30-year period roughly where you see this enormous growth in foreign law firms operating in China and then a kind of real decline of it. And one question is, well, what are they going to be doing? What's this going to look like in 5 or 10 years? Are they leaving because the work has just dried up? So it's just a business decision, or is it also related to the kind of state secrets law, other kinds of regulations that would make it harder to operate as the foreign firms want to operate? So if some of the new Chinese laws, for example, if they make it impossible to keep client confidentiality, then it's very hard to operate a foreign law firm, an American law firm in Beijing, if you can't keep your clients' confidences because they're state secrets or something like that. It's just very hard. I don't have an answer to that. I don't have a real opinion on why the foreign law firms are leaving. It's probably a combination of things. Um, and then the Chinese law firms that have gone global, some of those have crashed, right? The Dentons Dacheng marriage lasted a couple years, and then that broke apart. King and Wood Mallisons, I'm sure somebody on this call knows a lot more about that than I do, but the King and Wood Mallisons um, joint joint operation, the Verein that they had created, that has kind of fallen apart, it looks like. Um, so will Chinese firms that will they be able to do the work that the international firms used to do for the Chinese economy? And that's kind of an open, interesting question. It's not easy. It has not been easy for firms from Asia to come into the US market, for example, and really compete. Um, or will the Chinese firms that are global, will they really be limited to kind of the Belt and Road countries? Um, and ultimately, will Chinese law firms and bar associations, will the profession gain more autonomy from the state, from the Chinese government, the leadership? And if so, how would that happen? Like, what would be the forces, the factors that might support that, advocate for that? That's a little hard for me to see. Um, will it come from the lawyers themselves? Would they be strong enough to really push for that in the Chinese political system? Or would it have to come from above? Would you need the Chinese leadership to say, okay, for some reason we really need to loosen our controls on the legal profession? Um, so I'll just end with that. I've talked almost to the end of my time. But I hope that was interesting to people. It's a kind of a funny paper in the sense that it covers just a lot of ground. Um, so I hope people have enjoyed it and not. If you disagreed, I hope it wasn't too vehemently. So thanks for the opportunity.
Thank you, Professor Ohnesorge. That was really a comprehensive overview of the development of the Chinese legal profession over the years, over the centuries. We've got some questions here, and we have some time left for questions. So if I may just start with the first one, there is one question here which touches upon your last slide. Um, the In light of China's rapidly expanding economy, what implication might this have for the future of cross-border legal practice by Chinese lawyers? And you touched upon those, if I may add that, upon the outbound lawyering, so to speak. Um, how do you see Chinese law firms developing internationally? We know about some representative offices. You talked about the collaborations. How do you see that to develop in the future?
I would, well, this the it's very interesting, that historically it's been the US and the British firms that have been most successful at building these global law firms. Not to insult the Germans, but the way German law firms are run, French law firms, there's just something different, and I defer to people here on what exactly that is. But so if a Chinese law firm, say, wants to come into the US market, um, I think and succeed and be big, they'll have to hire lawyers here. And to get good lawyers, they'll have to run a little bit more like an American law firm. Um, I think they'll have to be a little more transparent about ownership and things like that. I mean, my comments are based partly on experience with Korean law firms. I mean, the Korean law firms sort of on the outside, they kind of looked like an American firm. The outward trappings looked like an American firm. They talked about partners and associates and these things. But my understanding of how they actually ran was they weren't really partnerships in the sense of an English or American firm. They were more like separate little legal fiefdoms, that shared office space or something like that. And so I don't know. I My impression of the big Chinese firms is that it may not be the big ones that are really best able to go international, because maybe the big Chinese firms are just not going to be flexible enough, and it'll be harder for them to adopt sort of American British style organization. Maybe it'll be smaller, mid-sized Chinese firms that will have more success. Um, and I think about the Dachang Dentons split. I think partly that was a culture clash. I in my uh, what I've heard from people who worked at Dentons and were part of this, it was just a culture clash. Um, about the way that the firms were run, and the expectations of the lawyers were just very different, and they couldn't overcome that. So I would predict actually there would be maybe sort of Chinese boutique business firms would be able to go abroad and be more flexible about their own business model. That might work better.
Thank you. Yeah, we do have time for one more question at least. Respect for law starts with respect for lawyers. Has the reputation of lawyers in China changed over time? Are lawyers always seen as honorable and impartial, or also as cunning and evil? And has that changed over the time?
Oh, well, there are a lot of Chinese people on this call, and I hesitate to speak about how Chinese people feel about Chinese lawyers. I mean, going back to the imperial period, it's interesting. I mean, why, clearly for a lot of people in China, those I call them proto lawyers in some pieces. The litigation masters, the litigation tricksters, or whatever. It was the official ideology that that they were bad and they should be suppressed, and that the anti-litigation songs, who wrote those, who published those? It was the government, but people must not have hated the lawyers that much, or they wouldn't have existed as a kind of profession. Um, so I don't know. I'm sure it's both. I mean, I'm as an American, we have conflicting views about lawyers too, right? We have views that lawyers are ambulance chasers and not really to be trusted, and they're deal killers because they negotiate too much and they fight too much. Um, but then on the other hand, a lot of people have very high opinions of lawyers, and a lot of people want their kids to be lawyers. Um, and so I don't know. I hope that lawyers in China, and this might be something that could drive forward a kind of liberalization. I hope that they're able to build and maintain a public image as really like defenders of rights and a profession that does more than just make money. It's a profession that actually helps improve the society. That I think it's hard to predict a positive future for lawyers in China if they lose that reputation or if they can't develop that reputation. So I hope that's the case.
This is the end of this seminar. Many thanks again to you, Professor Ohnesorge, for this wonderful seminar. The next Greater China Legal History seminar will take place on the 20th of March. We don't have a poster yet. That's why I'll take the liberty of announcing it like this. The role of the Solicitor General in Hong Kong, pre and post handover, to be delivered by Mr. Daniel Fung, SC and KC. We hope to see you all there. Thanks for joining, and enjoy the rest afternoon and have a good weekend. Bye-bye.